Hello everybody, welcome back to my channel. My name is Joanne. Look, Australia has got some very interesting defamation laws there, so we know that possibly Google may hide behind the US laws. But there is a case at the moment where a Twitter user known as PRGuy17, Twitter has been ordered to hand over the information of that user so they can be sued for defamation. And Crikey has actually got this article. PRGuy17, Friendlyjordies case show the internet isn't above defamation laws but doesn't need to change. Cases involving two high-profile internet creators have gained much attention. The situation is novel, but the cases are fairly clear-cut. Now, so online creators PRGuy17 and Friendlyjordies have both been involved in defamation cases. So PRGuy17 is a Twitter user that has been calling out the government. Seems to have some inside information. I mean, we know if you've seen Friendlyjordies' latest email video, he has actually got the personal email of or some email, from an insider to do with Barilaro. So these guys have some pretty good sources, and politicians, and the people aren't liking them. So in the past 2 days, two Australian court decisions about online political satire creators, PRGuy17 and Friendlyjordies, have painfully reminded some of an obvious and boring point. Yes, the law applies to the online world, even if sometimes we act like it doesn't. In the case of the former, the right-wing provocateur, Avi Yemeni, was pursuing the real identity of an anonymous and influential Labour-spooking Twitter account called PRGuy17, who he claims defamed him. Yemeni, an Australian working for the far-right Canadian media outlet Rebel Media, announced his intention to unmask the account in February, suggesting that revealing the identity or identities of the people behind the account is an end in itself as well. Yesterday, the court ordered by consent. Twitter and Yemeni's lawyers agreed, and I'm sorry if I said his name wrong, but that Twitter would hand over the name, the email, and IP address used to run the PRGuy17 account. There is actually a handle on Twitter that says I am PRGuy17. Everybody is using that handle as a bit of a protest. I'm not sure that it's going to work, but hey, good try, hey? On the latter, this week marked the end of a long-running defamation case filed by former New South Wales Deputy Premier John Barilaro against Friendlyjordies, the online pseudonym of Jordan Shanks, and Google over two videos published on YouTube that he alleged made defamatory claims about him. Barilaro and Shanks settled out of court earlier this year, I think it was last year. Google, which has been on the hook as the publisher of the videos, did not file a truth defence, meaning it did not argue that Shanks' claims were true. After progressively abandoning all defences, Google was ordered to pay $715,000 to Barilaro. Federal Court Justice Stephen Reyes also referred both Shanks and Google for possible contempt of court charges over improper pressure on Barilaro and his lawyers not to pursue the claim. Naturally, both these cases received a lot of attention. The main characters are controversial online partisans who've nurtured an audience of dedicated fans and haters who are interested in what's happening. The relative newness of social media makes it feel like this is something novel. However, these court decisions are far from landmark. University of Sydney professor David Rolfe told Crikey that court orders revealing the details associated with online accounts as part of a defamation proceedings is standard procedure in Australia, like the 2020 case when Google was ordered to hand over the identity of an online reviewer. That Yemeni seems to be seeking the identity of PRGuy17 for reasons other than exclusively using it to sue is irrelevant. The decision the court makes to order the release of such details is whether there's a reasonable chance a defamation claim will proceed, regardless of whether the proceedings happen or if the claims are found not to be defamatory. Either way, in this case, Twitter isn't being forced. It agreed to divulge such information. Twitter declined to comment. Google's big payout was the result of rejecting requests to take down videos that contained the claims that in the end the company did not argue in court were true. In Australia, it settled It's settled law that platforms owned by companies like Google have the responsibility for the content they publish once they've been notified of a complaint. Friendlyjordies' derisive statement after this week's result points out that Barilaro never had to defend against the claims in court. This is true. But it's also, unfortunately for him and Google, not the way defamation works. Shanks made allegations. Google published them. It's up to the two parties to prove them if a defamation proceeding is brought forward. It's not a freedom of speech issue. There's nothing stopping Friendlyjordies from making the claims he made in the video in the future. In fact, if Friendlyjordies believes his claims about Barilaro to be correct, he's free to republish his videos, which Reyes says contain some very serious and false claims, without the edits made as part of his settlement, and see what happens. Google clearly didn't think that it could defend them in court. Ultimately, Shanks agreed to a settlement, paid costs, and apologised. What is notable about PR Guy 17 and Friendlyjordies' case is that they demonstrate how the internet has made it easier to defame someone. Before the internet, they couldn't have existed. If PR Guy or Friendlyjordies wanted to reach as many people as they do, they would have needed a newspaper, a radio, or television station. These institutions come with gatekeepers who probably wouldn't have let them create content like that, like they have, probably losing part of their appeal that has come from creating a direct relationship with an audience, but also would have been another check and balance against potentially defaming someone. We're long past the point where the internet can be thought of as a wild, wild west, unbound by law. If anything, it's more treacherous for speech online. Offhand comments in context that once would have been snark with friends are recorded forever as data on foreign servers. A digital crumb trail means it's arguably harder to stay anonymous. Saying something online means there's a good chance it's tied to you forever. The final piece of this is whether the two decisions are the way things should be. Few people are shedding tears for Google. The Silicon Valley's company's decision to ignore Barilaro's request to take down the video seemed foolish, and perhaps one that reflected its American roots where platforms like YouTube aren't treated as publishers of content created by third parties. With Australia's robust defamation culture, the company will no doubt be more willing to take down content fearing bearing consequences of a defamation proceeding. Will they, though? The former coalition's government, poorly named Social Media Anti-Trolling Bill, could have changed that. The crux of it was like platforms like Google would not be liable if they made it easy to get the name and contact details of people who made online comments. The bill was never passed and so will remain a road not taken. In light of this week's Google finding, maybe one the company wishes we had. The second part of this is considering what bar needs to be reached to justify revealing the identity of an anonymous user. Online anonymity is a crucial tool for many, but not an absolute right, and in Australia, something that is a run-of-the-mill decision for courts to sacrifice. What happened here is Twitter decided to divulge details without waiting for a court to force it, or for the claim to be proven to be defamatory, a decision that Samantha Florini of Digital Rights Watch called chilling. It makes sense that people shouldn't be able to anonymously spread damaging lies to enormous amounts of people without some kind of recourse. Whether it's currently required legal hurdle to unmask someone adequately balances someone's desire for privacy in 2020 is a subject ripe for public debate. So it says this article has been updated to clarify that Google is liable for content published on its platform once it's been put on notice. So if you put in Australia, if you put YouTube on notice, then they are liable. That's why they've only been made liable for part of the time the videos were done. They've only been made liable for the time that they were made aware that there were alleged defamatory statements. So I'm interested to hear what you think about this. What do you think about the fact that PR Guy is now going to be unmasked? What do you think about this whole... I mean, we've got, Peter Dutton was suing over a Twitter post. So it just seems to be there's more and more defamation coming from social media. What do you reckon? I'd be interested to hear what you've got to say in the comments below. So until next time, there may be a few videos dropping in the next 24, 48 hours. Yay! I'll catch you next time. Bye for now.